You don't want to miss it. It is about David Copperfield, the magician who has a show out there in Las Vegas at the MGM Grand. And one of the audience members, one of the spectators, was a part of one of his magic tricks and got injured. And now he is suing David Copperfield and the MGM Grand for the injuries that he sustained when he fell in the course of a trick. But David Copperfield and his team are saying, wait a second. This injury had nothing to do with the trick. He fell on his own. It had nothing to do with safety precautions. We're not at fault. Now, what I want to play for you right now is a quick preview of that case in anticipation of our live feed later today. Take a look.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Cox, who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist who once cooked for British royalty claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during the disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
That's going to be a good case to follow, ladies and gentlemen. Again, we'll cover it here on Law and Crime. Again, we expect at 12 p.m. Eastern Standard Time, and as soon as we have a feed, we'll make sure to go to it. But right now, our focus is the Claude Tex McIver case out of Atlanta, this prominent attorney who is on trial for murdering his wife, Diane MacGyver. Now, he shot her from the backseat of a moving car. The prosecution says this was an intentional shot. He wanted to kill his wife, while the defense is saying, wait a second, this is all a tragic accident. He didn't mean to fire the gun. Now, this back and forth we've seen for weeks, and we'll see it all wrapped up today in closing arguments. But before we go to our live feed, and I'm looking at the feed right now, before the trial starts, I want to talk a little bit more about it. And I have two very special guests right now joining me. First up, we have Latonia Hines, from a criminal defense attorney who's actually outside the courtroom right now. So she's right there. She's about to go in. We're going to talk to her in a minute. And we also have with us host of the late feed on 11 Alive, Vinnie Politan. Vinnie, it's great to see you. It's great to have you both. But Latonia, I want to start with you because you're outside the courtroom. If you could provide to our viewers, what is the vibe like today, and what has the vibe been like throughout this whole trial? What's the environment like?
So let me just clarify a couple of things. I'm a former defense attorney. I'm currently a current prosecutor here in the metro Atlanta area. So in being in the courtroom, it's been very interesting to see a lot of the people who worked with Diane sitting there in the courtroom every day. A lot of the witnesses who testified who were released keep coming back. As a matter of fact, this morning I went upstairs to see the courtroom, and her personal assistant, who was very emotional during the trial, is there. I think today you're going to see a lot of emotions going on in this case. It's been a very interesting case, and it's going to be very interesting to see how both sides wrap it up.
What's the media like there? Is there a lot of people? Is there cameras? Is the courtroom packed? What has it been like?
So it's more packed today than we've had it most of the days, and there's also a media room, so you actually have a lot of the media that are sitting in that room. But you have more people in there today. It's very interesting, so much so that usually you'll see a lot of the witnesses who have testified before sitting in the center aisle. It's almost like a triangle, side on the left, side on the right, and the center aisle. And usually they're sitting in the middle, but because there's so many more people today, you have those people sitting on those two sides on the left and the right.
Right.
So today is going to be a very high attendance day.
I can imagine. So, Vinnie, what in your opinion, what does the defense and what does the prosecution need to do today in their closing arguments? Because the closing arguments are so important.
But it's really important in this case because you talk about trying to take a look at what the law says and apply what this jury has heard from the witness stand and in terms of exhibits and everything else. So from the prosecution perspective, I think the theme has to be guns just don't go off. Guns don't go off by themselves. Something has to happen for a gun to be fired. And I would definitely stress the fact that this is a guy who knew about guns, was very familiar with guns, and knew how to handle a gun. From the defense perspective, I think the one thing that they're going to say is, You want to know what happened inside the car? Listen to the three people who were inside there. All three of them agree on one thing, folks, that it was an accident. So I think if you start there and then kind of branch out to where the testimony went, I think it's kind of what we're going to hear this morning inside the courtroom down in Fulton County.
And Vinnie, let me just ask you a follow-up question. We saw yesterday the testimony of a sleep expert brought out by the state as a rebuttal witness and basically said, look, I'm not arguing with the defense's theory that Mr. MacGyver might have a sleep disorder, but I can tell you one thing. He wasn't sleeping when he fired that gun. It was impossible for him to be in that REM deep state of sleep that the defense would say, and therefore it really attacked their theory. What did you make of it?
Yeah, I thought it was good. I thought that was one of the weakest parts of the defense case. I think the defense did much better on the cross-examination part of their case than this sleep expert they brought in. But basically, he talked about something that I've been talking to a lot of my viewers about, which is, you know, if he was so scared and so afraid of what was going on outside of his car that night, driving through the streets of Atlanta, how could he just fall asleep again that quickly? And I've driven up that road, and it's a short drive from where he gets off that exit to where the gun ultimately was discharged.
Exactly. Latonia, I know we don't have much time because I know you have to head into the courtroom. Final thoughts as we go into the closing arguments today.
They need to be concise. I think at this point in time, there's no need to go and retry the whole case again. I think they need to hit on the main points, at least for the prosecution, for the jurors to remember the main points. The things like Vinnie's saying that don't make sense. The fact that you didn't hear anything about sleep until later. The fact that this is a gun and a gun doesn't just go off. They go in, be quick and to the point. And I think that's going to be the same thing for the defense. They're going to go in and talk about the weaknesses of the case and the fact that there's no smoking gun, excuse the expression, from the prosecution's case.
Okay, well, we'll have to see. Now, Latonia, you go in there. I don't want you to miss your opportunity to jump in the courtroom, so we're going to cut out. Thank you so much for joining us this morning, and we can't wait to have you back to find out what the reaction has been in the courtroom and what we know a little bit more about it.
Sounds good.
All right. So, Vinnie, stand by. What I want to do is we wait for the live feed in the courtroom. I want to play the testimony of a huge witness, a witness that was really crucial to the defense's case, Ross Gardner, a crime scene analyst, talking about the position of the gun and really helping the defense's case, showing that this was, in fact, an accident. Take a look at some of this testimony. All right, welcome back, everybody. So we have a live feed in the Claude Tex McIver courtroom, and let me tell you something, ladies and gentlemen. It is packed in there. It is packed. I don't even see an open seat. Everybody is going to watch the closing arguments from both the prosecution and the defense in this murder case. Remember, Tex McIver is charged with the murder of his wife, Diane MacGyver, and he also faces another count of influencing a witness. That's right. The prosecution believes that he tried to cover all this up by trying to conceal the fact that the driver of the car, Danny Jo Carter, wanted her to tell the police, I had nothing to do. Don't say you were involved in this. Don't say you were driving. I don't want you getting mixed up in this. Now, look at that courtroom. Look how many people are there, and look how many people are watching this. So again, joining me via Skype is host of the late feed on 11 Alive, Vinnie Politan. Vinnie, we're seeing this. I'm curious because today is so much about the attorneys, right? When they have the closing arguments, it's really about the style of the attorneys. I mean, in your opinion, what is your thoughts on the defense team? What were your thoughts on the prosecution, their different styles, how they were effective with the jury? What did you make of everything?
I think we almost saw a role reversal in this case. I mean, most trials that I've covered throughout, the past couple decades, the defense attorney is usually the flamboyant one. The defense attorney is usually the one that takes control of the courtroom and does things that are a little bit, over the line, so to speak, by being a little bit more outrageous, a little bit more flamboyant, a little bit more memorable. In this case, it's the opposite. I mean, the defense team has been pretty much reserved and they're very competent at what they do. But it's been the prosecutor, Clinton Rucker, who has been kind of the driving force inside there and the one that people are noticing and remembering. It'll be interesting now because he didn't do the opening statement, but he'll be doing the closing argument to see how that energy transforms. And it's really all about a relationship and a connection with the jury, because you need that credibility as well. They need to believe you. I mean, there's two sides to this story, obviously, because there are two sides in the courtroom. So you've got to make that connection, and you've got to be able to sell them on the way you see the facts in the case.
Do you see a situation where Tex McIver might not be found guilty of murder, but might be found guilty of involuntary manslaughter and maybe the witness influencing a witness charge, or he might be found not guilty of anything, or he might be found guilty of everything? Like, if you could explain to our viewers a little bit about how he might, this little menu of different items that he's charged with, he might be found guilty of everything across the board, and then there might be a little bit of this and a little bit of that. What do you think?
Yeah, it's a big menu, and that's important because this is if in fact there are jurors who see this thing differently, and they've got to negotiate sort of a verdict and compromise and try to agree on something. There's a lot of different ways they can go if they all don't believe one way or the other. So if it's not murder, if it's something less than murder, involuntary manslaughter is a natural place to go, and there's a big difference, right? Murder, life in prison with or without parole. Involuntary manslaughter, it's 1 to 10 years he's looking at, and he's already served a bunch of time. There's a couple of big things though that we have to remember that are in this indictment. Aggravated assault, okay, and it all depends upon how they interpret aggravated assault, because felony murder is another count, which is the same as murder in terms of life with or without parole. So I think the defense has to be careful with that one, and the prosecution has to give this jury a roadmap to aggravated assault, because that can lead to felony murder. Then all of a sudden the whole thing didn't have to be planned out the way, or you don't need that malice aspect that you need for malice murder. The other thing is there's possession of a weapon during the commission of a felony. This is an automatic 5 years, okay? 5 years consecutive to the underlying felony. So if, in fact, again, it's a not guilty on the murder, but guilty of another felony, and we know he had a firearm in his hand, you're going to tack 5 years onto whatever it is. And let's never forget what this all means for Tex McIver. The guy's 75 years old.
Yeah.
He doesn't want to do another day in prison, let alone a minimum of 5 plus whatever the felony is. So that's a loss. So anything other than Tex McIver walking out of that courtroom is a loss for the defense in this case.
That's a great point. That's a great point. It's a different situation if you had a younger defendant, and we've covered that before. We've covered cases where you have younger defendants that face life in prison and trying to really fight it. What we're going to do is we have the audio in the courtroom. There's a back and forth right now between the attorneys and the judge. So let's listen in, and Vinnie and I will talk a little bit more about this case. All right, let's talk about what just happened. I'm here again with Vinnie Politan. Vinnie, the judges removed the misdemeanor charge that the jurors would have been able to convict Mr. MacGyver on. So that was involuntary manslaughter due to criminal negligence, which is a misdemeanor. So now he's really only up for felonies, and that does include involuntary manslaughter due to reckless conduct. So in other words, he's facing the top charges here. He's facing murder. He's facing involuntary manslaughter due to reckless conduct. What do you make of this, the fact that the judge has gotten rid of that misdemeanor charge?
Well, I think that's, everything like that is good for Tex McIver. What's really interesting here is talking about involuntary manslaughter versus just a straight up accident, right? Murder, we understand what murder is. You do it on purpose, intentionally, you meant to do it. But then finding that line between a excusable accident and involuntary manslaughter, which is this reckless behavior. Where is that line, and how does the judge instruct the jury? And that's what Don Samuel is really concerned about, and what the judge is concerned about. Because, if this jury believes it's an accident, that's the defense theory. But where's the difference between an accident and this criminal reckless behavior? And that's difficult for lawyers to navigate, even more difficult for a jury to navigate. And that could ultimately be where this whole case comes down if they don't find him guilty of the murder. So This is really important.
Isn't that just a question of fault? So, for example, if I'll give you an example. If he fell down, if they were driving in a car, the gun was to his side, he wasn't even holding the gun. Let's say, for example, they hit a bump, he falls down and hits the gun by accident, and it hits and shoots his wife. You could see how that might be an accident, but wouldn't you say him immediately taking the gun out and placing it on his lap, let's even concede the fact that, based upon the defense's witness, Ross Gardner, that the gun was not pointed forward, it was not pressed against the seat, it was on his lap. Creating that action of taking a gun out in a moving car and falling asleep, that I don't understand how it could not be seen as reckless conduct.
Well, that's a great argument for the prosecution, and I think what the defense is going to say is, listen, he was lawfully allowed to do what he was doing. You're allowed to protect yourself. You're allowed to have a gun in the state of Georgia. You can have the gun in your car, and you can have it ready. So, yes, I agree with you. I think it's going to be difficult for this jury to say this is anything other than absolutely reckless. However, the defense has to concede all these facts. I mean, these are the facts that they've been handed, that all that stuff did happen, and they've got to make the argument that, you know, he was allowed to do it, he should be able to do it, and it was a tragic accident. It's difficult place because she's dead, he was holding the gun, but that's what the defense has to try to do today. They're battling more than the murder. They're battling this also because this could also land Tex McIver in prison for the rest of his life because he's 75 and the rest of his life is a little bit shorter than most criminal defendants.
Yeah, that's a great point. And we're looking at that packed courtroom. My gosh, are there a lot of people in there. I think the jury is coming in right now, so we want to stand by. But yeah, you know, and Vinnie, you said it so well. It's so important how the attorneys craft their words in their closing arguments because it resonates so much. Have you seen cases where it's a make or break based upon the closing argument?
Oh, yeah. I covered the Kennedy cousin Michael Skakel trial years ago when you were in like junior high or something. And in that case, all along, everyone was like, he's walking. There's no way he's getting convicted. Then we listened to that prosecution closing argument, and it was the best one I had ever seen. And it turned me around and obviously turned the jury around because he was convicted at that trial. So it can be done on both ends here.
And I think here's a case where it's so important because the facts can really be tailored to a different theory. And that's what makes this case so interesting, and I think that's why people have been following it so much, is because you can look at it both ways. And I think really at the end of the day, it's who has the stronger argument.
Yeah, how do you marshal the evidence? And did something happen during the course of the trial that, and this happened in the Skakel case, that none of us noticed, right? That sort of went under the radar, that all of a sudden you can bring out on closing argument and everyone's like, oh my goodness, I've seen it before and it may have happened here. We'll have to wait and see.
Unbelievable. And let me ask you, not the $1 million question, because the $1 million question is what will ultimately he be convicted of, if anything. How long do you think the jury will deliberate?
I think Friday afternoon. If this is a normal length of a jury deliberation, I would say by Friday afternoon, we should have a verdict. If it goes beyond Friday afternoon, I would call it a long deliberation. If we get something before Friday, I would say it's relatively short.
All right, Vinnie, the jury's in. Let's listen in. Stand by.
Let's do it.
Okay, that was the prosecution's closing statement, at least one of them. Let's bring in Vinnie Politan. Vinnie, what did you think of it?
I thought it was good. It was a roadmap. So you take the law, how the facts apply to the law. Not a ton of passion in it. We're going to get that, I'm sure, from Clint Rucker in the closing argument from the prosecution. But I thought she was clear. It was very easy to follow, which is what you need to do. You need to make it easy for this jury. They're not lawyers. They've never seen these statutes before. They don't know the elements of the crime. So lay it out for them so they have ammunition when they go into that jury room to come to the conclusion that you want. One thing, though, that really struck me, and this is what this whole case may come down to when we talk about murder. Was the gun cocked or was the gun not cocked? And it seems that the prosecution has now married themselves to the fact that the evidence is that that gun was not cocked. He had to squeeze that trigger with the 12.5-pound pull in order to shoot and kill Diane MacGyver. That is significant because that now comes down to, all right, well, if it was cocked, then it was an accident. So I think they've opened the door a little bit here for the defense by marrying themselves to that fact.
Yeah, I mean, that's really key. And I think for me, when I was looking at it and was listening, the idea of whether this was an accident under the law or whether this was reckless conduct. And I thought it was interesting. She says, I don't even want you writing that down that this was manslaughter. This was definitely murder. Now, again, I think there is a debate out there about whether or not this is a murder or whether or not this is manslaughter. But really, the toughest part for the defense, and I can't wait for them to talk about it, is how do you argue away that this was not an accident? You know, I mean, really, that's the crux here. How do you argue that this was an accident?
Yeah, well, and they've got to do two things, right? First, you've got to deal with the murder, but then you've got to deal with the manslaughter as well. And I think what they can do, based upon the way prosecutors have framed this for the jury so far, is to say, how do they know the gun was cocked, right? How do they know if that gun is it reasonable to believe that the gun may have been cocked? And then they'll rely on the evidence of their experts. And to me, that is so crucial here, because that jury's going to have the gun. The prosecution said, just ask the judge, and you can squeeze the trigger yourselves if you want to. So you know at least one of the jurors is going to want to do that in order to feel the difference. But is it possible that this entire murder case comes down to that one fact? Because I think there's an argument that even if the gun is cocked, you can still make an argument for murder, but it doesn't look like the prosecution is doing that. And clearly there's no way that you can accidentally squeeze it if the hammer was not slid back. So I know the defense is locked into that, but I thought the prosecution could have argued both. They're not doing that. So that is one important fact here. And I think the defense is going to talk about that a lot. And I think they're also going to talk about the relationship of Tex McIver and Diane MacGyver, and the fact that these two found each other and were having a wonderful life, and try to really undermine the alleged motive here. We'll see. But I thought she did a really nice job, but they're going to need some passion. I felt like there wasn't that attachment to the victim in the case. You've got to humanize the victim much more, and make the jury understand what this is really all about. It's not about charges, it's about someone's life.
Yeah, I felt a little bit like I was in a CLE class for criminal law, but it was okay, because we'll have to see what Clint Rucker ultimately does. Now, Vinnie, I know we have to let you go. Again, Vinnie Politan, host of The Late Feed on 11 Alive, covering this amazing case. We can't wait to get your feedback once we finish the closing arguments, and hopefully we get a verdict soon, and we'll be able to understand a little bit more about this case. So, Vinnie Politan, thank you so much for joining us.
Great to be with you, Jesse. Awesome job. Thanks.
Thank you. Thank you. All right, everybody. So here's what I want to do, as we are in a break right now. Today is closing arguments day. That's what it is. What I want to play for you is the replay of some of the closing arguments from earlier this morning. We'll do it for you. We don't want you to miss anything, because, again, it's a really great summary for anybody who's been following the case, or even anybody who's new to the case, to understand what's happening here. So, as we wait for the live feed back in the courtroom, here is some of the closing arguments from the state. Take a look.